probably the leading purveyors of disinformation in our entire society right now.
We were there when the governor staged and anchored his own TV-style roundtable to highlight grievances with what he calls the mainstream corporate press. And as if answering that call, lawmakers filed a bill this week that would make it easier for people to sue media companies for defamation. The backlash from First Amendment rights groups was immediate. Two of the people invited to share their expertise on that roundtable are here with us right now. Freedman is a South Florida attorney whose client was the subject of a report that CNN would retract and apologize for. Carson Holloway is a fellow with the conservative Claremont Institute who wrote an article recently about libel and cancel culture. And it is great to have you both on the program with us today.
Morning, Glenna. How are you?
Thanks for having us. Yeah, thanks for having us, Glenna.
So, Vel, let me start with you because your client was one example that the governor talked about this week of a story where the press mischaracterized a person or a situation and then ended up retracting what they had said, issued an apology. Is that appropriate consequences, or obviously you think there should be more?
Yeah, Glenna, I mean, my client in that case, as you mentioned, Zachary Young, was the subject of, as the lawsuit lays out, a report by CNN that claimed he had been operating on a black market when evacuating Afghans from Afghanistan after the U.S. pulled out and the Taliban took over. And the report went on to talk about how he exploited these Afghans and things like that. And after that happened, his business went to zero, just no more business, and he's been unable to support himself. CNN did apologize, but his business hasn't returned, and so I mean that's what our courts are for, I think, in situations like this.
So in this case, your lawsuit is about recouping any kind of money that he lost because of what happened. Carson Holloway, your article last month was really interesting. It was actually called Libel and Cancel Culture, and it argues that New York Times versus Sullivan should be revisited. For anyone who doesn't know what that is, that's a 1960s case that sort of elevated the legal standard for which media can be sued. That is the prevailing opinion and the prevailing standard. And that's actually in this bill. That was written into the bill that Supreme Court of the United States should revisit New York Times versus Sullivan. So unlike trying to get financial difficulties returned, compensated for, you argued for kind of a different standard. Why is that?
Yeah, that's right. I've contended in print or on the internet that New York Times versus Sullivan deserves to be revisited because it imposes a new standard with regard to libel, the so-called actual malice standard, which makes it harder for a public official or a public figure to win in a libel case than would be the case with an ordinary citizen. And so my argument is that that standard itself is not really rooted in the original meaning of the First Amendment. If you look back at how the founders thought about libel and freedom of speech, they simply treated libelous or defamatory statements as outside the scope of freedom of speech and of the press. And they didn't draw a distinction between public figures or public officials or other people. They thought it was important that the law and the ability to sue should protect everybody's right to their reputation equally. And I also argue in some things I've written that I think it creates kind of a dysfunctional environment for our democracy if you don't have a sufficiently workable standard by which public figures, as well as anybody else, can defend their reputation, because it kind of creates an environment in which the press doesn't think they have to be as careful as perhaps they should be. One thing I'd like to point out,
can I just go on the record and say, as a
Sure.
member of the press, I and my colleagues work very, very, very hard to be very careful and to be right.
Mm-hmm.
Just wanted to kind of throw that
On that point, Glenn, I think you have to put yourself back into where the Supreme Court was in New York Times versus Sullivan. Like you said, it's a 1960s case. It was 1964. At that time, the internet didn't exist, and news companies worked really, really hard to get things right. There were fact checkers employed, editors employed, and things like that. And since that court's decision, which the court appeared to believe was necessary to ensure robust reporting, right? That like we need to protect the media. We need to make sure that the media can go out there and talk about things without unnecessary consequences. But since then, the landscape has shifted with the advent of the internet. And now the internet has given everyone a podium or a soapbox to, get out there and say something. And that's changed the landscape from making sure you deliver correct content to enabling folks to battle for clicks and generate content. And so what we've seen is the media companies, not all of them, Glenna, but some of them or many of them, get rid of their fact checkers and their editors in favor of content to push out content. And so the New York Times versus Sullivan case has resulted in the situation where publishing facts without any investigation or without any fact checking is actually the optimal legal strategy, because in a sense, ignorance is bliss. And if you don't know that what you're saying is wrong, then you should be protected.
But it sounds to me, I don't mean to interrupt you, it sounds to me that the proliferation of, well, the internet wasn't around for New York Times versus Sullivan, but social media, Twitter and Facebook and Instagram, I mean, misinformation abounds, and, respectfully, many of it may be mistaken, and certainly some of it is absolutely intentional. But then how do you protect legitimate news operations from that kind of media?
Well, why wouldn't a normal negligence standard protect the media, right? In ensuring that nobody's saying the media should be held strictly liable for something they say that's wrong. But what the law would do if it was revisited, I think in many people's view, and I'm sure Professor Holloway will have some views on this, but the law should revert back to this stance where the media, like everybody else, should be held accountable for what they say. And that means they need to do a reasonable investigation. They need to take reasonable steps to ensure what they're saying is right and accurate. If they fail in that, they should be held accountable. Why are they held up on a pedestal and given protections and immunities that other people are not?
So, Carson, what Vel is saying, consequences for people that do things wrong, that sounds perfectly legitimate. But how do you then, we're not talking theory here, we're talking this is in a bill to become Florida law. So how then do you sort of protect a news organization's ability to operate without fear of being bankrupted in good faith?
Well, that's an important consideration. I think it's worth mentioning, too, that although there's controversy over a bill like this, there are actually things that everybody agrees on, which I think is everybody agrees that freedom of the press is a vital principle to our democracy. So we don't want a situation in which news outlets can be bankrupted by frivolous suits. On the other hand, everybody agrees, or should agree, that persons' right to their reputation is also one of the key values that the law seeks to protect. So even if one were to reverse New York Times versus Sullivan, which I don't think would be required if this bill were passed and upheld, but even if that were to happen, you would still have freedom of the press. We had freedom of the press before New York Times versus Sullivan. It was not routine for news organizations to be bankrupted before New York Times versus Sullivan. Yeah, you have to have some care in the law and the amounts of damages that can be awarded. And as Vel was saying, the standards by which you would have to demonstrate that someone had actually defamed another, which wouldn't just be the press, by the way. I mean, the law doesn't look only to the press, but to anybody who defames another citizen. Under the current standards, you have to show, if you're a public figure, actual malice. You have to show that they knew they were lying or that they acted with reckless disregard. If you took that standard away or constrained it, you would have to show that someone said something about you that was false in the first place, that was damaging to your reputation in the second place, and as Vel was pointing out, that they did it negligently or carelessly. So I think that's a standard that would be reasonably balancing of the various considerations that we've been talking about.
I want to steal a couple more minutes from you, but I need to hit a break. So if you stay tuned, we'll be back in 2. Back with attorney Vel Freedman and Carson Holloway, a fellow at the Claremont Institute, talking about a new bill filed this week. Defamation is the title of it, and some really quite stringent plan to cut back on mistakes that the press might make, whether or not intentional, and the way to levy consequences against that. Vel, I want to throw something out at you that's part of this bill. The bill states that anonymous sources will automatically be presumed false. And while that on face value actually makes a lot of sense to a lot of people, I'm sure, having had reports, read reports as a consumer with anonymous sources. And I guess if you throw it way back to Deep Throat in Watergate, anonymous sources are kind of a last resort for reporters, but certainly in some cases critical for very important reasons. Weigh in on that if you would.
Yeah, I mean, I think the bill is aimed at, I think, the broader problems that are found within the defamation context. And, to put that in perspective, Glenna, Justice Gorsuch has recently joined a dissent from the Supreme Court's refusal to take up a case on certiorari. And in doing so, he cited statistics. He said that the defamation trials have declined dramatically over the decades since the New York Times decision. And that even once you get to a trial, he says the very rare successful plaintiff that actually wins after a jury trial has a 1 in 5 chance of losing on post-trial motions and a 1 in 10 chance of losing on appeal. And so I think the bill is recognizing that the cards are stacked against innocent people who are being really hurt by defamation, who can't make the showings that the court has required. And so it aims to do a lot of things to fix that. One of which is what you talk about, this presumption that anonymous statements are false. If that bill were to pass and were be upheld, against constitutional challenges, or the court were to revisit that standard, then, Glenn, I think it would put the onus on media companies to really investigate an anonymous tip before they go forward with it, because it would be difficult for them to rely on that without showing that they reasonably did so.
Carson, I want to hear your perspective on that as well, and maybe throw in, might that have a chilling effect on reporting?
Yeah, the chilling effect discussion is a very interesting one, and I would look at it this way, and then I'll come back and say some more about the anonymous sources in a moment. A chilling effect sounds like a bad thing, and in First Amendment discussions, it's always treated as a bad thing to have a chilling effect on freedom of speech and freedom of the press. And of course, in a general sense, that's true. But on the other hand, we are talking about people's right to their reputation and the right to be free from being defamed. So if the legal standards create a chilling effect on defamatory speech, that's not necessarily a bad thing, right? Media or anybody who speaks and uses their freedom of speech and of the press to attack other people's characters need to make sure that they're telling the truth. So that's worth noting.
Can I just jump
Sure.
in here? That's a large assumption that they would use the freedom of the press to attack character. I'm not sure I've ever met a reporter who did that, ever.
Well, I mean,
Glenna, sorry.
Go ahead.
Sorry, Professor Holloway.
Oh, I've touched a nerve here.
Yeah, I mean, I'm litigating a case right now where we've got, Mr. Young sitting here with no income because of what we allege was a completely false and defamatory segment by CNN. One, I'll point out that they apologized for after we sent them a demand letter, a legal letter threatening suit. So,
Understood. I guess my question is that was that a mistake on they didn't do their due diligence, or was there malice involved?
Well, obviously, Glenna, we believe malice was involved, but I'm sure the case will play out, and obviously there are certain orders in place. We can't talk about some of the things we've seen in the case, so I can't comment on that specifically in this case. But what I can say as a more general matter is Mr. Young would have really appreciated a chilling effect on CNN's rush to publishing, so that they didn't have to issue the apology, because the apology didn't fix anything. But a chilling effect would have been quite nice.
Understood. Okay. Carson, continue. I wanted you to finish up on that.
Well, just on the point you were making there, Glenna, I mean, you said that you're very careful to fact check, and I believe you, and I believe that's true of most journalists, but it only takes a few who are careless or who are animated by some kind of malice to do harm to individuals' reputations. I would think about it this way. It's equally true, I think, that most people who are in business, most contractors, most doctors, do their best to do their job correctly, but you still have laws that allow people to sue when they're injured, because there's always a handful who don't do a good job. And I think that's part of what's being discussed here. With regard to the anonymous sources, I just think it's worth noting that is kind of a new development. It's not a brand new development, but I don't think that the reliance on anonymous sources was as common at the time that New York Times versus Sullivan was decided. You mentioned Deep Throat and Watergate. That goes back quite a ways, but it's still several years after New York Times versus Sullivan. So this is a post-New York Times versus Sullivan development that has created certain issues or problems in defamation law that I think the legislators are trying to address. Yeah.
Glenna, the
yeah.
bill is broader than just that one issue that you've talked about. There are some very non-controversial portions of the bill, like shifting of attorneys' fees, venue provisions, and other areas that I think folks would agree are not controversial constitutionally. So, just keep in mind, it's a broader bill than the portions you're highlighting.
100%. And I just want to throw out there that one of the constraints of television news is time. And I wish we had 4 hours to talk about every single part of the bill, but we don't. So let me just leave it here and say that bill is online. Everyone can read, #read the bill, read it for everyone's own firsthand information. So Carson, Holloway, and Bella Freedman, it is so good of you to give up a little piece of your Sunday morning. This was a really fascinating discussion, and I appreciate you both.
Thanks a lot, Glenna.
Thank you, Glenna.